Hello YouTubers. Through this channel I'm hoping to educate the public about laws, at least as far as India is concerned. Uh, this channel is going to start from diverse topics and it's going to continue to have diverse topics on it. I hope that I come off in an entertaining manner, and I hope that at times I'm also quite boring and just educative. This channel is focused on educating students. At the same time, it's also focused on educating the general public. So I'm trying to blend the two. I give a disclaimer that all facts and figures and all information provided on this channel should be verified, and legal advice should be taken as each case is different from the other, and due to this something that I might say on this video might not apply to your case. Therefore you are always recommended to go to a lawyer and get your case checked and get proper legal advice. I hope my first video, which is an introduction to law, is entertaining, informative, and I hope you guys like it. Thank you. Hi guys, so this first video is about an introduction to law. We commence with the history of law in general, how humanity began and how Indian law started taking shape. We also discuss the different types of rules that took place and eventually how India got independent. We also discuss what exactly law is and the different types of laws, codified, uncodified, substantive law, procedural law, and we also focus on statistics of India, how law plays a vital role in this country, and towards the end we conclude with the importance of the constitution and how it governs laws in India. So let's get right in. Let us begin with the history of law, and more importantly, the history of humanity. It is a scientific belief that human civilization first commenced on the happening of Holocene epoch, which started at the end of the Ice Age, about 12,000 to 14,000 years ago. During this phase, the Earth underwent great climate change, which led to the extension of humanity's mega food source, the mammoths. This gradually led to humans having to cultivate land, which was then a safer bet as far as food source was concerned. Slowly, human population started increasing, and so did the number of settlements. This was the start of a civilization. It is believed that as man realized that he had surplus of certain goods and that he required others, he started to trade them for what he lacked. It is also believed that the barter system started about 10,000 years ago, with the first record of barter being found in ancient Egypt around 8,000 years ago. Following this, precious materials were also used in the form of statues and other forms for the purposes of trade. The first currency was introduced and invented by Turkey around 2,600 years ago. Lost in its inception, laws started to grow from human instincts and beliefs, especially after the creation of property and valuable security, which had at the time become something required to be controlled and protected so as to prevent the abuse by men with power. India has a recorded legal history starting from the Vedic ages. During the Vedic ages and the time when the Quran was written, it is not right to say that these were codified laws, because they did not prescribe methods of sanction or methods of execution and enforceability of the law they were prescribing. It is also believed that some sort of legal system, civil in nature, has been in place even during the Bronze Age and the Indus Valley civilization. Secular law in India varied widely from region to region and from ruler to ruler. Court systems of law civil and criminal, were essential features of many ruling dynasties of ancient India. Excellent secular court systems existed during the Mughal and the Maurya rule, which later gave way to the common law system. The common law system, a system of law based on recorded judicial precedents, came into India with the British East India Company. Throughout the ages when India was governed by different rulers and different kingdoms, the king was declared as the most supreme authority to decide vital cases which had grave implications on the entire kingdom. The king used to use his councils who would help him in interpreting the law. Most of these councils were highly intellectual people of their time. It was also a belief that the king could do no wrong. It is very wisely said that with great power comes great responsibility. The abuse of power by the king eventually led on to the creation of the great Magna Carta, where equality of law and equal protection of law itself became the law of the land. The East India Company, having come into India 400 years ago under the Charter of King George I, established mayors' courts in Madras, Bombay, and Calcutta. Judicial functions of the company expanded substantially after its victory in Battle of Passy, and the company's court expanded out from the three major cities. In this process, India saw an expansion of its legal system as far as the British legal system is concerned, and a collapse of the Mughal legal systems. Following the First War of Independence in 1857, the control of the company's territories in India passed to the British Crown. Being part of the empire, the next shift of the Indian legal system began. The Supreme Courts, I might say again, the Supreme Courts were established, replacing the existing mayoral system. So, initially, there were multiple Supreme Courts in India, which later on happens to dilute into one Supreme Court. These Supreme Courts were then converted into High Courts through the letters patent authorized by the Indian High Courts Act, passed by the British Parliament around 300 years ago. Until now, laws were not really codified, and the first coding of law began in earnest with forming of the first Law Commission. Under the stewardship of its chairman, Thomas Bigginton Macaulay, the Indian Penal Code was drafted in the year 1860, about 140 years ago. At the dawn of independence, around 70 years ago, the Parliament of India was to forge a document which would guide the young nation in its new phase. This document was drafted by none other than the great Dr. B.R. Ambedkar, who formulated the Indian Constitution of the newly independent nation. The Constitution of India is the guiding light in all matters, executive, legislative, and judicial in the country. The Constitution turned the direction of the system originally introduced for perpetuation of colonial and imperial interests in India firmly in the direction of social welfare. The Constitution explicitly and through judicial interpretation seeks to empower the weakest members of the society. The Indian system of law is focused on social justice, and it is not limited to Indian laws and precedents, but it also borrows Commonwealth system of law from its neighboring territories. If we take a moment to step back and try to understand what law is, we would observe that the general definition of law states that law is a system of rules which a particular country or community recognizes as regulating the actions of its members and which it may enforce by the imposition of penalties. So, what this basically means is that law is simply a set of rules, set of conditions in order to ensure the smooth functioning of a society, in order to ensure that members of a society are interacting in such a way that it's beneficial for all. When we talk about law, we talk about two types of law, two major classifications. The first two and the most important classifications of law are codified and uncodified laws. Earlier, I did mention that in Vedic times, though the priests and the holy men went on mountains and they attained a state of meditation where they became super beings and they acquired intellect and knowledge from the higher power. These teachings of theirs, which were laws in a way, were not written or were not in a system of words and letters and figures or symbols, and therefore they were conceptual, they were in the form of intelligence, and therefore they were classified as uncodified law. On the contrary, when we wrote our constitution and penned down exactly what conditions and what rules would govern our country, that became codified. That became codified law. So, India has two major types of laws. Like many other countries, it has got codified, those laws which are written down and can be read at any time, and uncodified, which are not written down and are on the basis of principles such as natural justice. The next type of law is substantive law and procedural law. Substantive law is any law which determines rights, duties, liabilities, powers, immunities of any of the parties. These laws basically tell us the substance. They are what are the rules and regulations of how people will behave. Whereas there is procedural law, which are rules and regulations of how the substantive laws will be enforced and what is the method of approaching the courts, of approaching the judicial system, which would ensure that substantive laws are enforced. Therefore, there are two categories of every codified law, which is substantive law and procedural law. If we look at the basic ingredients for law, we would come out with four such ingredients. The first being a legislation, and for that a legislator. The need to prevent something bad for society. A punishment to ensure that in case prevention is not achieved and a crime is committed or an wrong is done, then there should be a sanction, a punishment for that wrong, and enforcement. That sanction or the punishment should be enforceable. If there is a punishment that a person needs to be hung and there's no way to hang him, then it's as good as not having that law. Therefore, these basic ingredients are required. One, a person who's competent to declare a certain rule. Two, a problem that requires the rule to be put in place. A punishment for the violation of the rule, and somebody to ensure that the punishment is given. Let's talk about the statistics of India and the reason why law plays a pivotal role in India. As of 2019, the population of India is at 1.35 billion people, and the area that India covers is roughly 3.2 million square kilometers. Uh, this is vital because we need to understand and put in perspective that India, having such a large landmass, uh, has so many individuals interacting with one another on a daily basis. Therefore, uh, it is very obvious that a large number of contracts are executed every day. These contracts need to be enforceable, otherwise, it would be meaningless to enter into contracts. And if people became barbaric, there would be total amok in the nation. So there would be riots, and people would loot things and cause devastation in the country. Therefore, these laws play a very essential role, and it is important that citizens know of these laws so that there's a regulation on these people from going crazy. Uh, India is a federal union. What that means is each state has a state list under the constitution, which permits it to do which permits it to decide the laws under that list. And in times of need, the central government takes over charge and dictates terms to the states. These are very crucial times when, for example, an emergency takes place. There's a state of war, and the entire country needs to function as one unit. So when that is required, the country changes gear and moves into a union state. Uh, the highest judicial authority in India is the Supreme Court. So we start from the district courts, the lower courts, trial courts, and move our way up to the Supreme Court. And that's in cases of civil matters. In cases of criminal cases, we start at the magistrate courts and we move our way up to the Sessions Court, to the High Court, and then eventually to the Supreme Court. At the state level, the High Court is the highest court or judicial authority, and in addition to all of this, India has got 29 states and 7 union territories, a total of 36 different jurisdictions which form India. India's central legislation is a bicameral system of legislation with a Rajya Sabha and a Lok Sabha, and most of the states are also bicameral in nature, having a legislative assembly and a legislative council. The legislative organ of the government is the organ which creates law. So as far as we are concerned about how law is created, it's the legislator, and how it is enforced, it's the judiciary. How it is not really enforced, but how it is interpreted and upheld is through the judiciary's orders, and how it's enforced is through the state machinery of its police and through the central machinery of its armed forces. So that would be the statistics of India and the relevance of law in this country. Coming to the final part of this episode, the Constitution of India. The Constitution of India deserves an episode of its own. In fact, I would say it deserves 10 episodes of its own. However, for the purpose of this video, which deals with law, we will only be looking at certain aspects such as Article 13 and the 7th Schedule. So, before the Constitution, we were under the British rule, and a noteworthy fact is that Britain had no written constitution. Therefore, it was an uncodified constitution, and we were following that. We were following the Queen rule, the King rule, and that was about it. However, when India decided to get its independence, our forefathers decided to lay down a foundation, the bedrock of our governance, of our democracy. And this constitution is regarded as the most advanced constitution, as it has taken a large number of aspects into consideration, and it has concluded in 448 articles. Also, it contains 12 schedules. These schedules each having their own essence. For the purpose of this video, once again, 7th schedule is the most crucial. So let's begin with Article 13. Article 13 defines what law is and what law is to be permitted within the country. So a plain reading of the section, article, is all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void. So immediately this part, we are talking about the fundamental rights, part 3 of the constitution, and as far as this part is concerned, it is the most essential part, as it gives every citizen the right to liberty, the right to freedom, and it gives them right to equality, right to not be discriminated against, etc., etc. So if any law is there which curbs these rights, then that law is to be void. The second sub-article of Article 13 reads as, the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of contravention, be void. Again, it is explicitly clear that no law shall be passed which would curb the fundamental rights of the citizens, and the state's power to make any such law has been curbed by this article. Moving to the third sub-article, in this article, unless the context otherwise required, law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. Laws in force includes laws passed or made by a legislature or other competent authority in the territory of India before the commencement of the constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in any particular areas. What this basically establishes is that law, what we earlier were going through, was that law is basically a rule, a regulation, a code of conduct, so to say. However, this definition expands it to include an ordinance, which is a 6-month legislation passed by the government in cases of emergencies and on very limited scope. Law is also an order. It is also a bylaw. It is also a notification. It is also a custom. Now, while we are mentioning that it is all of these items, it must pass the second test, which is the subclause B, which says that it has to have been, if it was before the constitution, it has to have been made by a competent legislator. Without the competent legislator, it could not be considered as law. Therefore, a normal person passes something and says that this is a notification and this is law, will not be acceptable. Thus, what the constitution in Article 13 is doing is it is ensuring that whatever law is to be considered as law and to be enforceable in this country has to clear Article 13 and has to fall within the purview of Article 13. There are other articles which talk about how so the 7th schedule, let's come to the 7th schedule. The 7th schedule contains something known as the central list, the union list, the state list, and the concurrent list. Now, these three lists are very vital to understand. The union list contains subjects which only the union has the sole right to legislate on, to pass laws about. So, those entries made in the union list are only for the central government to make laws on. Then there is the state list, and as the name suggests, only those items on the state list can be legislated by the state legislation and not by the central government. And the third list, which is the concurrent list, allows the state to make laws. However, in the interest of the public at large, if the central decides to legislate over it, the central's laws shall prevail. So the state can make laws on those subjects, there's no doubt about it. However, in case the central government thinks that they need to intervene, they have the full right to intervene on those items. With this, we conclude the basic structure of law and what law exactly is in India and where it derives its power. For one last thing that is important is that the constitution itself can be amended, and in this comes the most important judgment, the landmark judgment of Keshwananda Bharati, where it had been held by the Supreme Court that the basic structure of the constitution cannot be changed. And what do they mean is that once the forefathers had decided that India would be a democratic, socialistic, sovereign, basically the words contained in our preamble, once we had fixed our preamble, what this country is going to be, then nobody, no legislator, no court of law, nobody has the right to change that basic structure, because that structure was created by the people for the people. And keeping that in mind, it has to be remembered that if the constitution at all has to be amended, it has to be amended without altering the basic structure. That's all for now, and hope you all enjoyed this presentation come informative video. Thank you for watching, and please subscribe so that I may make further videos. Thank you so much.